With the expansion of the internet in recent years, the notion of employee privacy and employer privacy is rapidly changing. My guest is Outten and Golden partner Wendi Lazar. She heads the Executives and Professionals Practice Group with the firm with offices in New York and Chicago. Wendi, it's a pleasure. Welcome back.
Oh, thanks, Scott. A pleasure to be here.
And I also know that you're busy. I appreciate you taking the time at the office there. So what, in just general terms here, there are a lot of layers here, and I'm sure that, this differs state by state, but in general terms, what privacy expectations does an employee have with regard to, for example, electronic communications, using a company's electronic devices or on the company's premises and their communication networks?
Well, Scott, the private workplace is just that. It is a private place where the employer really has control over its communication devices, including its mobile devices, its computer system, its telephones, and this is not new case law for sure. It has been this way for quite a while. What has really changed, I think, dramatically over the last few years is the fact that now we have communication devices and we have people in the workplace, in the private workplace, that are working all the time and are using these devices for both their personal and their work life, so that the lines are becoming a little bit blurred.
And so with that kind of statement in mind here, it's often difficult for the employee, for example, to know where to draw the line, because as you said, a lot of times they're communicating, they're working off premises, they're using their own email, they're using their own social media perhaps, and it sounds like it could be very, very confusing.
Well, it is confusing, and I think what the courts certainly across the country have made very clear, including our own Supreme Court, is that policies, that employers need to set very clear, written, cohesive policies that let the employee know what they can do and what they can't do, whether or not they can access their own private emails during the day, whether they can shop online, whether they can have email communications that are confidential, using certainly the computer of the company or not. These policies, or text messaging on a BlackBerry or a cell phone that belongs to the company. I think clearly if you're using an instrument or certainly the data at your place of business, that this is going to be, it's very important for an employer to set clear written policies. Having said that, however, it is very hard to tell an employee who's involved, let's say, in a lawsuit that has nothing to do with work, that he or she can't possibly contact their lawyer. Same thing if someone is not, has a medical report that they need to access, or to get a prescription from a doctor. These conversations, these emails, may need to be done at work and certainly during work time. And the courts have given some freedom here to employees and have really gone out of their way to protect employee privacy, certainly in the context of attorney-client privilege. We know that certain states say that even if you speak to your attorney through email on the company's computer, it's not confidential. So the Supreme Court in New Jersey made it clear that an employer should not be looking at an employee's confidential information, confidential communications, I should say, with his or her lawyer. And in the context of even lawsuits that an employee brings against the company, courts have found that these emails are not discoverable, and in fact have gone so far as to sanction the counsel of the employer or the company for actually looking at these emails.
Let me ask you this, a potential situation, it's frequent that an employee will be given an email address, a domain. And an employer has many things to protect, from intellectual property to company secrets, etc. And certain employees are highly valuable. if an employer, for example, again, it varies state to state, suspects that an employee is talking to a competitor looking for a job over there, where does the law stand about the employer looking at that person's emails, especially if it's the company email?
Well, if it's the company, we have to be very clear on whether or not it is the company email and whether or not it is the employee's Gmail or Google Word or whatever site they happen to be using at the time. These are complex situations. On one hand, the employer absolutely has the right to protect all its confidential information and can do something, for instance, like logging in to their entire server, which may contain open Gmails from an employee, let's say. And certain states allow for an employer to make mirrored images of their complete, all of their data, and anything that's been open on that server at the workplace. On the other hand, there are states that have made court decisions, certainly New York is one of them, that have made it very clear that an employer cannot, without authorization, access Gmails and other personal, MySpace, or any personal emails without authorization. If they happen to find out a person's Gmail password, they can't just go into that and use it and open it up. That is actually a violation, Scott, of what is called the Stored Communications Act. It's federal law. It's part of the Electronic Communications Privacy Act, and it is very serious when an employer violates that. It also cuts the other way when an employee authorizes emails and other information that they should not have access to. And someone working, a mid-level manager, can't go into the office of the CEO and basically break into their computer to access emails and other information. So it cuts both ways, the Stored Communications Act, and it's been used against employees and also to protect employees, and the same thing with employers.
So with regards to, again, in closing here, the general notion of privacy, is all this, from a liability standpoint, is all this civil, or is there a criminal penalty sometimes?
Well, there is something that I warn employees about all the time. You're looking for a new job. You're asked by the new company to send information that you may have done at the job, in the old job, in your current job, and you're being asked by either an employer, a new employer, or even a recruiter at times. Let me see what you've done. Let me see the work you've done. Let me see this profile. Let me see this strategy. Well, sending trade secrets or proprietary data from your current employer to a possible future employer or a recruiter can result in trade secret violations, which can be considered criminal. And it's very serious. It gets increasingly more serious in particular industries. We've seen it in the car industry when there is really high-level trade secret information being sent from one employer to another through an employee. And we've also seen it in the financial services industry, where it could result in a serious SEC violation, where information is being sent either home to someone's home computer, to their Gmail account, or what's absolutely, of course, worse is when information is actually sent to a third party.
So Wendi here, I guess in closing, what do you recommend employers do now to protect themselves and to set up, at least some sort of policy with their employees?
I think, Scott, the answer to that question is to have clear written policies that really describe in detail what an employee can and cannot do on a workplace computer, what they can use, what they can't use, and certainly on all the devices that the company owns. But in addition to this, I think employers also need to understand that there are certain limited privacy rights that employees do have. They can't use their they can't use employees' private passwords to get into their Gmail. That's a no-no. They can't, otherwise monitor without advising the employee that they're doing so. So those are the really big issues. I think in terms of employees, it's amazing representing employees and executives as I do and as our firm does. It's amazing to me how often an employee will come in and say, I did A, B, C, and D, and it's on my company email. Or I'm looking for a job and I sent out my resumes on my company email exchange. And my response is, get your own BlackBerry, get your own iPhone, get your own iPad, whatever you can afford. It could be anywhere from $49 to, of course, much, much more. But if you have privacy, private issues to deal with it on a private device. And don't involve the company in your private life. And, if you must use a computer at work, certainly go into your own email if you can, and that will protect you, at least insofar as the states that observe the ability of an employee to use their own private email at the workplace.
All right, again, my guest has been Wendi Lazar. She is a partner with Outten and Golden and heads the Executives and Professionals Practice Group. Wendi, I know you're busy. Thanks for sharing your expertise with us today.
Thanks so much, Scott. I appreciate it.